All right, good morning, everyone. We're happy to see you here, and this is going to be the meeting of the JQC Study Committee. We have a quorum present, so we'll begin. I think we have a couple others who may be walking in a few minutes. I want to go through a couple of preliminaries. We have, at last meeting, announced that we were inviting the current members of the Judicial Qualification Commission, of which there are 6. Mr. Hyde is here today. Appreciate you coming in. Mr. Ed Tolley, who is a member, is not able to make it today, but he's going to come next week, and I'll announce about the meeting next week. We'll have a time change partly to accommodate his presence. Miss Linda Evans is not here because she's got a bad head cold and health reasons. Jimmy Franklin announced in an email to us he previously had plans to be out of state today. Again, we can certainly accommodate him if he wants to come in later. Lester Johnston says he has a conflict. Patsy Porter, who's chair of it, declined without reason, and Tara Moon, who is an employee of the commission, also declined without reason. So we have for hearing today Mr. Richard Hyde, and I'll ask if there's not anything preliminary issues from the members of the commission. Mr. Hyde, if you will come forward, please, sir. I would also announce that next week, because of Ed Tolley's schedule needs, we're going to start our meeting next Thursday at 1 o'clock rather than 10 o'clock, if that's okay with the members of the commission. Anybody have objections to that? If not, we will plan to start our meeting next Thursday at 1 o'clock, excuse me. Mr. Hyde, as I have announced to other individuals who appeared before the committee, we are allowing the members to give an opening statement. We would ask, first of all, that the court reporter president administer the oath to you.
I do.
And I'll also, as a preliminary, state that you forwarded to me a document which dealt with the JQC public actions as reported by news medias over several years, and I have taken the liberty to have that distributed among the members of the commission. So if you have reference to that at times, you're welcome to do so.
I want to make sure everybody understands neither I nor Mr. Davis wrote that. A young man at the University of Georgia Law School wrote it as a project and sent it to us.
Understood. Glad you made that announcement.
Right. I don't really have an opening statement other than to thank all of y'all for the invitation. I'm sorry that I'm the only one here. This has been a long time.
We are too.
This has been a long time coming. I think you and the people of the state are deserved some answers to whatever questions you want to ask, and I'm prepared to sit here till the Lord returns if need be.
Yes, sir.
I think, first of all, we all owe, when I say, and I want to make sure you understand, I'm speaking for me and not the commission. I'm not the investigator. I'm a commission member.
Yes, sir.
The governor's appointee. But as far as I'm concerned, we all owe Judge Becker and Judge Scoggins apologies for the way they were treated. But I think there can be some good to come out of both debacles, and I hope today to try to help y'all identify where the problems are that I think, give you some examples of the way cases come in. I will not use names of any judges that have not otherwise been publicly identified or charged. But I hope I watched. I was not able to be here last week, and I apologize, but I did watch it, and I want everybody to understand, and it may be because of youthful exuberance, that we're not the Wild West, and I don't search judges' offices, or desks or any of the stuff that I heard. There's a difference in a judge's bench and a judge's desk, and I hope you will ask me for my opinion of how that happened. But we do need reform. I have said for almost a decade, it looks bad for the same people to investigate, charge, and try. And I've said it to anybody that would listen, including you.
Pull your mic a little closer to you with this high so that
How's that?
There you go. That's better. Thank you.
I've always thought we needed a hearing panel, and I've always thought the hearing panel should be separate and detached from the commission, so much so that they don't even exchange Christmas cards. I think that a 3-person or a 5-person panel presided over by a trial judge who may or may not vote, but who makes rulings every day on different issues of evidence and whatnot, preside over it. But the commission itself, the 7-person or however it is you guys reconstitute it, would be more free to investigate and not have to wear more than one hat. The first case I had was about a decade ago, and I was called by Ben Easterlin, who was a state bar president who served with great distinction on the commission, as have
Yes, he did.
many bar members have served with great distinction on the commission. Many judges have served with great distinction on the commission, and even some non-lawyers have too. But Ben Easterlin hired me to go investigate in South Georgia in the Alapaha Judicial Circuit 2 judges that had complained on one another. And I did the investigation, and we hired Leah Sears, I believe, and Mike Bowers to prosecute the judges. And some of the, after about 400 cases, some of these run together to me. So it may not have been Leah Sears on that one. She may have prosecuted another judge. But the commission at the time always tried to hire good, fair-minded people to prosecute the cases for them. And I got back to Atlanta after the case, and I said to my boss, explain to me, because it looks odd, given my background, that the same people investigate, prosecute, and then try. And I was told, well, that's true, but they get due process. Their due process is notice and a hearing, and then whatever the commission does or doesn't do, the Supreme Court has to sign off on it. But I thought since that day that it just looked bad. The commission, it's important to note, doesn't deal in reality. We're the appearance police. Judges deal in facts. The commission partly deals in what does it look like to the public. And I think that distinction needs to be drawn. But we blew it on Becker and Scoggins. And I am here to take the punches for that, even though I didn't have a whole lot to do with either case, as you will hear. But insofar as I was not on the commission, I don't believe for either case, I was the investigator. And to my then boss's credit on Scoggins, as you heard, I think, the first day of testimony, once he figured out what was going on, we shut the case down. But again, we still owe an apology to both those judges. I'm not defending any judicial misconduct, just like you guys have not. I do need to say something to clear the record, though, Lester Tate and I don't agree on what day of the week it is, I'm sure. But I will tell you from sitting there, and the other members that were sitting there, Lester Tate never stood up, got red, or put his finger in Judge Becker's face. I will leave to you to decide whether he raised his voice, because there's an audio recording that he ordered filed when we filed the charges on Judge Becker, and you can hear for yourself. That recording, notwithstanding what some of you may have believed or heard, was not leaked. That recording was filed and released with the Georgia Supreme Court at the same time we filed these formal charges. And I don't remember if I physically brought them down here, or if a staff member or a secretary, or if they were e-filed. I don't remember.
Yes,
but that audio recording was filed and released. It was not leaked.
Yes, sir.
Judge Becker talked about, she said it a couple of times, it's not the JQC it used to be. Well, when I got hired, the policy of the commission was we only accepted complaints that were sworn to and in writing. So, and as far as we're not the commission we used to be, I'm proud of that. So proud, in fact, that the way that we investigate judges in Georgia is used as an international model of how to investigate judicial corruption. And it was not my idea, and it wasn't Jeff Davis's idea. The idea to change the philosophy of the way we take complaints in belongs to Ben Easterlin and a great judge and a certified American hero, Judge John Allen. And it was their decision to say, yes, we're going to still take complaints in writing, but it's not reasonable to expect a judge that shares a secretary with the judge that hadn't been at work in 3 months to file a written sworn complaint. I will give you an example without naming. I get a call one afternoon. For some reason, these things happen on Friday afternoon when I'm sitting at my law firm. I get a call on a Friday afternoon, and it's a chief judge of a superior court that you all know. And the judge says to me, please come to my office as soon as you can. Could be any number of things that I was being asked. So I call Judge Allen. I tell him I've been asked to go to this judge's office. I go walking in, and there's half the bench of Superior Court. And they say, and they named the judge, our colleague hadn't been to work in months and months. And you need to do something about it. So I left that meeting and I called Judge Allen, who I believe at the time was the vice chair, but had been appointed to be my immediate supervisor on exigent things. And Judge Allen said, well, go check into it. Well, I know the judge that had allegedly not been at work, and I went to that judge's home. I've known him for years. He was working in the yard. I went pulling up, and he looked at me, and he said, I know why you're here. This has been a long time coming. Would you come back in 1 hour? So I went and got a milkshake at the McDonald's, and I showed back up in exactly 1 hour. He was standing at the end of his driveway, and he handed me a letter, and he said, would you please deliver this letter to Governor Perdue? That was the extent of my conversation with that judge. I'm not smart enough to know if his due process rights were violated. But he didn't complain. Now, and that's not one of the judges you're going to read about that the University of Georgia Law School student wrote about. But there are many of those. Some of the examples are so grotesque and vile that I'm reluctant to even talk about them without a direct quote, because there are ladies in the room. But there was a clerk calls me or calls Director Davis and says, I work for a judge and he's sexually harassing me, and he's asked me about my oral sex practices with my judge. So I'm dispatched down to meet with that judge, and I'm interviewing him, and he admits it, and he leaves. Now, he had a right to a public trial, which I explained to him. He had a right to subpoena witnesses. He had all these rights that you guys have been talking about that I agree with. He chose not to do that. And so you're clear, I have never mentioned to a judge but one time the word resignation or you should quit. What I have mentioned scores of times is this, and the commission voted to authorize me to say this. And these words are from John Allen. And those words are, Judge, whoever you are, given the nature of the allegations, if true, what do you think the appropriate sanction from the commission should be? 90% or so of those judges decide to leave then. Another example, on a Friday, I'm at my law firm, I get a call. It sounds like a male. He says, I'm a detective in a county police department. The sheriff gave me your name. I was in the lobby of the courthouse this afternoon, and I heard two women talking about being somebody in their office being sexually assaulted by a judge in his chambers. And they worked for the DA's office. That's all I knew. He hung up. I called the director and or the chair, and I recounted what was said to me. And I was told by Judge Allen, go check it out. Had a formal complaint been made? I don't know. Certainly not a written complaint had been made. But we had an allegation of a judge sexually assaulting two women in his chambers. So that Saturday, I go meet with the judge. The judge admits it. The judge wants to quit right then. And I said, because we have been criticized, and I would say unfairly, of violating due process or waterboarding judges into resigning or using the news media as a hammer to beat them over the head with, I said to that judge, I'm going to leave. You need to call your wife, your preacher, a lawyer, and the next thing, and we'll talk again. And the judge said, the last thing in the world I can do is talk to my wife about this. Who are some lawyers that deal with this type of thing? And I gave him the name of some lawyers that we all know. One of them that was one of the best around, and I'm at the judge's chamber, and I look up, and here come two lawyers for the judge. I was outside. They meet for an hour or so. They came out of the judge's office with a legal pad with the judge's handwritten resignation to the governor and asked me to type it. I don't know what I was supposed to do. Did that judge have a right to a public trial? Of course he did. Did he have a right to confront the witnesses and to subpoena documents and to get all of that stuff that people died face down in the mud to allow him to get? Of course they did. But that judge and his legal team, one of whom was Roy Barnes, chose to leave right then. That's how quickly these things happen. Our best sources, and you folks have mentioned, well, we get a lot of complaints from judges about due process and specifically about me. I get that. My background, and none of you know me, I was a City of Atlanta police officer, and I would challenge any of you to go to any precinct right now at roll call and take a vote among the patrolmen and detectives and say, everybody raise your hand that wants to outlaw or do away with the internal affairs section because they're SOBs. I would tell you 90% of those patrolmen would raise their hands. But I would also tell you, up until 2 years ago, and even till today actually, the best sources of information of misconduct on judges are other judges. It wasn't that way when I was hired. It wasn't that way until Ben Easterlin, John Allen, Robert Ingram changed the way that we operated. So when Judge Becker says it's not the commission it used to be, what I have to say about that, notwithstanding her mistreatment, was thank goodness. And I think if the public understood all of these, for example, I'm interviewing a judge on a serious allegation, and the judge did something. He was a knucklehead. He was a new judge. He did something that could have been argued was removable. I am sent by the commission, and I want you to remember what Jeff Davis's testimony was the first day up here, that I didn't do anything that wasn't approved and ordered by either him, the chair, the vice chair, or the entire commission. I want you to remember that. So I go meet with this judge after Judge Allen tells me to, and Mr. Davis tells me to. The judge is emotional, as many of these are, and the judge wants to take his life. He has a pistol on his desk. He's going to kill himself. And For whatever reason, Mr. Davis happened to be in the courthouse, and I texted Jeff. He probably still has the text. And I said, get in here right away. The judge is going to kill himself. And like a guardian angel, within milliseconds, Jeff was at the door and talked this guy off the ledge. And this man is a judge today and one of the finest judges in our state. He had done a dumb thing. The commission dealt with it. But that's how these things happen. They happen that quickly. Of course, judges have a due process right. And when I'm talking to judges to explain to them the process that is not my process, it's the process that was approved by the Supreme Court in 1972, when I tell them they have a right to a public trial, almost without exception, I can see a light bulb going off in their heads, and they don't want a public trial. There was some discussion with Judge Becker about the docketing and something about 2015-01, and she didn't know the docket. There's a simple explanation for that, and it's pretty pedestrian. We hired a new director. Well, first of all, we're on the fiscal year like you are and not the calendar year. So it was 2015 fiscal year, not calendar year. That's why the year difference. But number two, when Judge Lane came in as director, he noted that our numbering system, which never made sense to me either, a complaint gets a number when it comes in, then it gets a complaint, it gets a number when it's presented to the commission, and then it gets a docket number after that. And Judge Lane, in the middle of the Becker investigation, started, if a complaint comes in, it gets one number, and that number stays with it forever. So that led to some confusion, I'm afraid, on Judge Becker's part. The timing of the audio recording that was released on Judge Becker, again, it was not leaked. It was filed. You can ask the reporters here when they got it and how they got it. I have no idea. There was a judge, I was in South Georgia, near where Mr. Powell's district is. I get a call from a high-level state law enforcement official who says, there's a police officer with a alleged prostitute pulled over. She's got meth, but she's telling on a judge, and they want you to go over there and talk to her. So I go from Camilla to an entirely different part of the state, and I meet with a lady, and she's credible, and we send her in to meet with the judge. She goes in to meet with the judge, and I'm monitoring it, and I had given her one of my business cards and wadded it up, and I said, go in and law enforcement was involved in this, because they're the ones that called me. Go in there and say, you just got out of jail, but this, I won't say how I described myself, but it was, a fat so-and-so just came to the jail asking me about my relationship with you. And the judge said, well, for God's sake, don't tell him we've been having relations, and certainly don't tell him we've been snorting coke together. That judge had a right to formal charges in a public trial. He chose to resign when the informant left his office and I went in. He quit. I don't know what else you folks wanted me to do. Yeah, he had a right to a public trial. If judges had public trial, however many of these there are, if every one of them had a public trial, I would suggest to you, I wouldn't be sitting here right now, because you and the public would understand what's going on with the judges. As I travel the world, I get asked frequently, what's wrong with the judges in Georgia? Because people read what's going on. And I have to say there's nothing wrong with the judges in Georgia. I would argue that we have the finest men and women on the bench in the country, if not the world. They're overworked and underpaid, and we're lucky to have them. It is all but a few, and it is those few that embarrass the rest. Part of the problem, Ms. Oliver, is when a judge leaves office, because he sexually assaulted 2 women in his office. He doesn't tell his buddies, I'm leaving office because I sexually assaulted 2 women in my office. What he tells them, and I get this, Hyde showed up, threw some resignation papers at me, waterboarded me, and I just had to quit. Do you really think that a washed-up motorcycle cop can sashay into some of the toughest men and women's offices in the state and they just decide to quit because I showed up? It doesn't happen that way. But I understand why you get misinformation, because the judges, we don't report all of that in our filings to the Supreme Court, and that is above my pay grade. I don't decide what gets filed with the Supreme Court. I was the investigator. But I have to, forgive is too strong of a word, but I have to tell you I understand your outrage about what you've heard about our tactics and procedures. We're not perfect. But I got to tell you, I was a page for Bob Bell, Harry Geisinger, Jim Tysinger, watching the legislative practice in elementary school on up until last session. It ain't perfect either. We can do better. And I hope that when we're done, the commission is better. We had a judge, the only time, I mentioned that I'd been authorized one time to mention that a judge resigned. We had a judge, a brilliant jurist, who did something dumb on the bench. He pulled out his Glock semi-automatic weapon and he pointed it at folks. And it took about 3 minutes for Jeff Davis to get a phone call from several people that were in the courtroom. Jeff convened an emergency phone meeting, almost instanter. And the commission voted unanimously to order Jeff and myself to immediately go to that judge and say, you can leave today, you can resign today, or we go for an emergency suspension. That is the only time of the 400 or so judges I've investigated where I've said, or Jeff has said in my presence anyway, you got to go. And we were ordered by the commission to say that. There was a threat to public safety, and our vice chair at the time said, we have zero tolerance for that. That's not to say everybody gets run off. I like to say that we give judges second chances. There's a judge that calls me frequently. I talk about him all over the world. He's a success story. He wanted to be here today and welcomes an opportunity to come anytime. He had an issue with alcohol. He recognized the issue with alcohol. He was before the commission several times. We gave him a second chance and a third chance. And today he's among the most brilliant jurists our state's ever had. And I will give you his name later. And I would suggest to you that you also talk to judges that have left, besides Becker and Scoggins, who are 2 aberrations, and again, we screwed up. Talk to Brooks Blitch, the first judge I ever investigated, who was ultimately indicted by the United States government. Talk to him. Talk to Pascal English. Talk to one of your members that was a Superior Court judge and ask him, I challenge you to ask him how he thinks I treated him. I challenge you to do that. And let's get back to searching judges' offices, because that really concerns me. That after 400 judges and doing this for 10 years, do you really think I would have lasted more than a week if I was searching judges' offices? That doesn't happen. But I understand why you would think that. Here's what happened. There was a judge in a major circuit who, during a trial, it's a criminal case, was writing vile, racist, bigoted Post-it notes to the law clerk who was sitting on this side. It outraged the law clerk and the staff members of that judge. without me knowing it, and they certainly were not my agent nor the agent of the commission, they surreptitiously kept those Post-it notes and filed a complaint, a confidential complaint. I didn't go through the judge's trash. I didn't go through the judge's desk. The people that did were on the judge's staff. Those people did it without my knowledge until after they had done it. I certainly wouldn't have encouraged them to do that. But that's just one example. There was a judge, one of the last cases I did as an investigator is grotesque. And it was reported by some volunteer ladies at the YWCA who escort victims of domestic violence through our court system. They do it for free. And they call and say, and then I was ordered to do this investigation. I don't just wake up in the morning and show up at a judge's office. You've got to get up here. This judge is out of control. You won't believe it. So I go to TPO day, and there's a couple hundred people in the courtroom. Some prominent lawyers you all know, and some of whom have run for statewide public office. And I'm sitting on the second row. And I'm not a small man. I don't wear a disguise. I know this judge well. He didn't see me. And this woman that had been repeatedly battered by her meth-addicted boyfriend was asked the following question, and I heard this, and it's on the record, and 200 people heard this. Lady, why should I grant this? Do you even work? Do you even do anything other than spread your legs and stay pregnant? Did that judge deserve due process? Of course he did. He had a right to a public trial. He had a right to subpoena all these witnesses. He chose not to do that. And when those words were uttered, I called the chairman of the commission to report back, and he said, I'm on the way. And to the chairman's credit, the chairman and myself, we didn't meet with the judge. We, at the chairman's suggestion, and it turned out well, we met with two of the judge's best friends in the courthouse. And the chairman sat down with these two friends, and he said, here's what just happened. This is going to be bad. And the friends of the judge went to the judge, and the judge resigned. Now, did the judge have a right to a trial? Of course he did. I would prefer, like I said, a trial on every one of these, every one. But that's not what the judges want. I had a sheriff call me, the high sheriff of a county in middle central Georgia, and the chief superior court judge, who you all know, been on the short list many times for a court of appeals. And they said, we have a judge down here who's out of control, erratic. We don't know what he's going on, and he's smoking marijuana in his office. And Judge Becker suggested last week, well, you know, the police should get involved. Well, maybe they should. I was a policeman a long time. And if you really want to dig deep into these 66 or so judges, as a layperson, certainly not as smart as you lawyers, I can pull out some violations of the criminal code if that's the way we want it to go. I was dispatched to meet with that chief judge and the high sheriff of that county. They told me what happened. I reported it back to the chairperson, who at the time was Judge Weaver, and she said, go handle it. I go meet with the judge. In plain view on his desk is a quantity of marijuana. I say, Judge, we got a problem. What's going on? He's depressed. He's self-medicating. He's got all these family issues. He chose to resign right then to the chief superior court judge and the governor. He wasn't waterboarded. Nobody searched his office. He could have been prosecuted for the marijuana, I guess. But if the high sheriff of that county and the chief superior court judge choose not to go the criminal route, that ain't my call. I'm an investigator for the commission. That's all I really have to say right now, other than I want to help y'all fix the problem. We need a new constituted commission. We need a separate hearing panel. And I think you folks understand that and can fix it.
Well, thank you, Mr. Hyde, for your comments. And I think we're going to open it now to questions, and I usually lead out. I want to first ask you, you've had a long history with the JQC. Can you give us an oversight of what that time frame history is when you served as investigator, when you also served as a commission member? I think you've been on a commission as a member 2 different times?
Yes, sir. I've been appointed by Governor Dill twice.
Okay. What was you mentioned about 10 years ago, is that about the beginning of your service with the commission?
Yes, sir. The first case was for $45 an hour to do one case in the Alapaha Judicial Circuit. Mm-hmm. The complaint had come in October. The then director and commission had done nothing with it until the following April when I was hired. Mm-hmm. So that would have been 10 years in April. And I was the investigator until there was a vacancy for the governor's appointee. And the governor asked me if I was getting burned out, as you folks probably can understand. I mean, I'm the tip of the spear. Yeah. Like Judge Becker pointed out that she makes rulings that make people mad, so send her to charm school. Well, we're the smallest agency in state government with the smallest budget. Our budget was increased thanks to you and the Speaker and Mr. Powell and the Governor, but we're still the smallest agency in state government. Probably the smallest agency that does this type work in the country. But I was hired for that one case.
Yes.
And it turned into the second one and the third. And one of you said the other day, I forget which one it was, and I probably took it the wrong way, that you've got this contract investigator out here doing this and that. I was a contract investigator because, quite frankly, I do other stuff. And most of you on your committee know that. I've done work for y'all. I do work from Maine to Montana and all over the world. I could not afford to just be a full-time state employee. It was offered several times. So I don't look at being a contract investigator as something derogatory, as some of you may.
No. I guess, do you know the times you served as far as dates on the commission as
for certain, I know sometimes. For certain, I know that I was appointed on December 31st, 2015. I resigned as investigator and went back on the commission. I think 2 years prior to that, and the dates are in here somewhere, there was a vacancy. The governor asked me if I wanted it, thought I might need a break, and I was honored to be offered the position by the governor. The governor said when he appointed me, along with his staff, in 6 months, if we haven't found, or if you haven't found another investigator to continue what you and Jeff Davis have done, would you consider going back on the commission? And I said yes. Well, 6 months passed, and I would bring in different people for the investigator job. Nobody was satisfactory. And I thought maybe the governor and his folks had forgotten about the 6 months. They had not. So when we were not able to find anybody else, I guess, stupid enough to be the point of the spear and take all the slings and arrows, I resigned from the commission and went back on as investigator.
Is it, since your service in December 31st, 2015, was it? Or,
yes, sir.
So for the last, almost year? Has there been anybody else doing investigative work during that time?
No, sir.
How is it managing the caseload, I guess?
I think it's not. I think that we're impotent. We've had a lack of leadership for various reasons. But we're backlogged.
You don't have a director now,
No, sir.
correct? Haven't had a director since Mr. Lane left. Is that right, Judge Lane?
Well, there was Mr. Daler, if you're
Daler,
considering
excuse me,
him
I'm
a
sorry.
director.
Yeah, Mr.
Yes.
Daler.
Yes, sir.
And besides that, then you had, he left, what, back, this is now the end of September. He left, I believe, what, early August?
I don't,
Sometime?
about a year
Right.
ago.
Has there been any interviewing for a director?
Not that I know of.
Okay.
But you understand, I'm the only non-lawyer on the commission. So there's a lot that goes on now that whereas under different commission members and different leadership, I would have known. I have no idea what's going on.
Well, that begs the question, why would you not know if you're standing as a level with all the other commissioners? If they're doing something, do you not have a right to be informed what's happening?
You know, that, again, I'm a street cop. I think I do. I think I'm a sovereign constitutional commission member representing the governor and 10 million Georgians. But I know I sent you an email that I hope you shared with your committee that laid out why I'm not being, complaints are being withheld from me, and I would suggest a couple other members.
Well, if they're being withheld, by whom are they being withheld?
I'm told that our acting chair has said no complaints get distributed without her direct permission.
Okay. The thing that goes back, and I certainly understand, and just like with criminal cases, Mr. Hyde, most criminals, thank God, plea. I mean, when you get the facts put to you as far as what you've done as criminal conduct, your natural place, you may first say, you know, not guilty at the arraignment hearing, but you know you got to find a way one time down the road to say, yeah, I plead guilty, I accept the crime, the punishment, et cetera.
Right.
Required to stand up in front of court to do that. So I don't have any problem with the fact that the judge says, yeah, you're right, I did something really major screw up. I'm not worthy of the honor of serving as a judge. I guess the ones I go to are the ones where somebody does have a complaint filed, unless there's something that may bring about a need of emergency removal of that judge. Do they always get a copy of the complaint with the opportunity to respond to it? And I say this, preface this, I've heard from judges where that has not been the case.
That has not been the case. There's a good reason for it happening occasionally, and there's a bad reason for it. Let me tell you the good reason. I don't know the percentage. I would have to defer to Jeff Davis, but I would say over 75 to 80% of the complaints filed through the formal process off the website or in writing are litigants unhappy about custody or alimony or things that do not fall within the Code of Judicial Conduct. Those complaints, the commission has authorized the director, when we have one, to dismiss. And Mr. David, and I've seen him, he hand wrote a letter, a personalized letter to every person that filed a complaint saying, thank you for your complaint. However, your complaint does not fall within the Code of Judicial Conduct. Your complaint is more of an appellate issue. Not to say that those are mutually exclusive. I heard Judge Becker talk about there's some things that are legal error and then there's ethical things. No, that's true, but there are things that overlap also. The canons say judges shall be faithful to the law. We had a judge in Middle Georgia that was doing unconstitutional burden shifting who told the defendants, young lady, it ain't you to prove you didn't do it or that you didn't do it. It's not up to it's not up to the trooper to prove that you did it. It's up to you to prove that you didn't do it. So was that a legal error? Yeah.
Yeah.
It's also an ethical error, and we filed charges on him. They're right here. Mm-hmm. We had a 3-day trial, and he was removed by the Supreme Court. So they're not mutually exclusive like Judge Becker is under the misimpression of.
Well, I understand, but again, we know that a lot of complaints get dismissed for the reason you say, that they're not to the level of saying there's been a violation of the canons of ethics or criminal conduct may be involved, which may be within the canons also, I'm not sure, but certainly if there's criminal conduct, that's cause for a case going forward. Now, the case, once it's reviewed by a director or whoever, and it says, okay, this case has potential merit as to conduct.
Right.
And I read your rules, and the rules say at that point that complaint should be provided to the judge to have a opportunity to address and respond.
Absolutely.
And I'm saying I'm hearing from judges where that situation did not occur and was not what I consider to be a quote emergency situation.
Well, that's wrong, and I'm not aware of that.
Yeah.
But that is not within keeping of the rules. What may be happening is the complaint comes in and it's not dismissed. When we have a director and an investigator, the director will do a little bit of phone work or research on the issue and then put it on the monthly agenda when we can have a quorum. We've had trouble getting some representatives to the meetings. When we have a quorum, the commission will talk about the case and then decide, okay, well, let's invite the judge in or send the judge the complaint and let him review it and respond. Sometimes the director can do that on their own without a meeting. Usually a letter goes out, a copy of the complaint and a letter to the judge saying, please respond within 30 days. And that's the way that should happen. And if it doesn't happen that way, that's on us.
Well, has it happened to your knowledge?
Not that I know of, but you're saying it is, and I have no reason to doubt you. But that, again, I'm the investigator. I only get complaints that people give me.
Gotcha. I guess stylistic also, the question comes to my mind when I see the letters that go out with just a number up there. And I speak now as a lawyer, with what we've got here as all lawyers. We don't have a style of a case. It's not like a complaint of John Doe, case number. It's just a case number, a docket number, what do you want to call it?
That's wrong. It was an error, and I'm only aware of that happening under one circumstance with one director.
Really?
Okay. As I said,
yeah.
I'm only aware of it happening with one director and one circumstance.
Yes.
I will state in my place that every document I've ever seen, either Ms. Custer or Mr. Davis write, had the style of the case and the case number.
Okay. Do you know why a circumstance would bring about a change of that?
It shouldn't. But you know, in the defense of our immediate last two directors, we kind of hire them and throw them in there. And nobody, I mean, we just kind of throw them out there, and there's not overlap sometimes. Mm-hmm. Jeff Davis was lucky enough that there was an overlap between him and his predecessor.
You think we get Jeff Davis back?
Well, when you folks at the bar stole Jeff Davis from the JQC.
Well, we'd like to steal him back, maybe. I see.
There wasn't a lot of overlap because Mr. Davis, as you know, filled in an exigent circumstance with the State Bar of Georgia. He didn't have a lot of time to do on-the-job training to people, and quite frankly, I'll say it again, I'm not a lawyer, so I investigate and I act as a commission member. I don't have standing to sit down with a lawyer generally and teach them anything, because unlike what a lot of the JDs mean, junior detective, I'm not a Juris Doctorate, and they don't listen to me. And I'm not suggesting they should.
How would you describe the current state of the JQC?
It's an embarrassment.
Why?
Do you read the daily report or watch Mr. Belcher's reports?
From your perspective, you're a commission serving member. What do you see as being?
Some of the appointing authorities, I think has been corrected now, have not paid particular attention to the type of people they have put on the commission. I don't think you ought to be able to appoint yourself to the commission. These are important positions. If we're calling in a judge, where the commission does its best work is at our monthly meetings where we call in judges and talk to them. You never hear about those. We bring in the judges confidentially, and the members will say, you know, you did certain things, you ought not do that. And to have that, to have one of the members or two of the members on the phone, unless it's a health reason, and it's a speakerphone in the middle of the table, and you have a judge and his lawyer at the end of the table, and the chair says, well, member so-and-so, do you have any questions? And their secretary says, well, he's not here, he walked down the hall. Well, first of all, that judge knows that we violated his confidentiality already, and in my view, it's disrespectful to deal with somebody that's either been appointed legally or democratically elected, and we're talking about their future and their livelihood and their reputation, and it's on a speakerphone. That's wrong.
What you brought up also brings back what Judge Becker said about not having knowledge that her informal conversation with the commission was being recorded. Is that, in fact, what happened?
No, I don't know what she knew. I know what I did, and I know what's happened in other meetings. I have listened to the recording from her appearance before the commission. Mm-hmm. The chair, at least I didn't hear, for whatever reason, there's no audio that prefaces it by saying, we're going to record this if you don't mind, so on and so forth. Every other case I ever remember, and it started with Judge Allen. Judge Allen would say, Judge, thank you for being here. We got a recorder here. We're going to make a recording if you don't mind, and we will provide you a copy. In Judge Becker's case, I did not hear that, but I do know from sitting in the room that the recorder with a red light on it was in front of her. Now, maybe she didn't see it. Her bacon was in the fire that day, and I can understand her not seeing a recorder in front of her, but it was in front of her. I put it there, and I turned it on.
Mm-hmm. We've also heard from time to time indirectly about leaks, and understand correctly the information regarding the filing of Judge Becker's recorded meeting with the commission as not really being a, quote, leak because it was filed with the papers going to the court, correct?
Yes, sir.
And was that in the Supreme Court?
Yes, sir.
Where
that's the only place we file charges.
Okay.
It's publicly in the Supreme Court, 7 copies.
Okay. And had she at that time already agreed to resign?
I don't know.
Don't know what time was?
That's above my pay grade.
All right. But we have heard other times where information has been apparently, I call it leaked. Certainly the judge didn't maybe tell about it, but do you know of instances where this has occurred or why it would have happened?
Yes, sir. I can give many examples of that. In one case, Mr. Davis and myself were negotiating with the judge through our chair, and we thought we had the matter resolved, and the next day the judge, or a day after that, goes to his buddy, the publisher of the newspaper, to give his side of the case, and gives him a photograph that corroborates the reason the judge left, and gave an interview. Another judge who leaves quietly, I thought, gets on TV and gives a full interview and admits all of his misconduct. Some of it is accidental. For instance, on February the 18th of this year, our then director accidentally sent the commission an email, or what he thought was an email to the commission, and instead of Richard L. Hyde at balch.com, he sent it to richard.belcher at wsbtv.com. That's right here.
Okay.
There are other times where leaks have been discussed in the commission meeting, and given my background, I'm usually the first suspect. But I will say again in defense of Lester Tate, the last time that happened, Mr. Tate spoke up and said, y'all are wrong. I did that. and I will continue to do that if I need to.
A leak?
Yes, sir.
Why would a commission member be feeling authorized to do leaks?
Well, he was asked that question by the members and gave an explanation, and I think you should ask those members or Mr. Tate.
Well, we haven't come before us. We would like to.
Well, I'm here.
I know you are. But did you know what his explanation was?
I don't remember, but I mean, I cannot speak for Mr. Tate, but I can defend him that he admitted that he gave the information out, and I can tell you that he did not stand up, turn red, nor put his finger in C.J. Becker's face.
Okay. Members of the commission, Ms. Oliver, you have any questions?
Thank you, Mr. Hyde, for being here. Your statement that the commission needs changes and is an embarrassment implies to me that you intend to vote for the constitutional amendment. Is that correct?
I don't know how I'm going to vote yet. I want to see how you people come up with the fix, and I haven't decided how I'm going to vote on anything on the November ballot, Ms. Oliver.
Well, I wasn't going to ask you about anything else. You are a member of the working group working on some solutions for procedural matters. Is that correct?
Yes, ma'am. I have the draft right here that we've been working on myself. Let me just thank God, and my bosses aren't going to appreciate it. Thank God for the Georgia Supreme Court, particularly Justice Namias.
And those procedures may not be able to be implemented unless the constitutional amendment is passed. Am I right or wrong about that?
I respectfully disagree. I think the rules, as stated now, say that the commission writes the rules and they are promulgated, whatever that means, by the court, and pass or fail. I would be for changing the rules today.
Are you for expanding the number of members of the commission, and would that require passage of the constitutional amendment?
I don't think it would require passage of a constitutional amendment. It might. Let me just say, since you asked my opinion, and I'm a hillbilly populist from Fort Oglethorpe.
Yeah, I'm a country lawyer from Decatur.
That's right. No faction, no appointing authority should have a plurality on this commission. There are some states that the plurality are regular folk. They're not lawyers, they're not judges, they're just people. So you may need an amendment to take the plurality away from the bar, which ought to happen. You don't need an amendment for these rule fixes that are way overdue. I've been talking to anybody that would listen about our rules. For example, our rules right now say, talking about Judge Becker, that the, I guess you call him the respondent in the way you lawyers talk, only get what is presented to the commission when they vote to file charges. So I gave 377 or so pages to Judge Becker's counsel and supplemented it, not that I had to, with multiple emails to her then counsel saying, here's all the commission's authorized me to give you, but my office is literally across the street from yours. You are welcome to come over here, ask me any question, look at any piece of paper you want to. The case never got that far.
Do you support expanding the number of the members of the commission from 7 to 9?
If it takes a plurality away, I would. I would support expanding it as long as it has nothing to do with the hearing panel. The hearing panel simply must be separate and detached and should not even exchange Christmas cards with the commission.
In relation to the rules, let me go back to that. There's been a discussion about what the rules were prior to Ben Easterling and what they were after Ben Easterling. Was there ever any written documentation about that change you've alluded to?
And which change is that?
That first complaints had to be made in writing, and then afterward they did not have to be made in writing. Was there ever a rule change about that?
If you're talking about rule change insofar as the rules of the Judicial Qualification Commission. No, ma'am. But the rules always allowed that. They just weren't interpreted that way. And as you know, you get 7 lawyers, you're all going to have a different idea of what the rules mean.
So the judges in the community, the 2,000 or so judges, never were aware that that rule had been changed because you, the commission,
No, ma'am.
took no action to promulgate or to publicize.
No, ma'am. It was highly publicized by media. Jeff Davis and I went on a speaking circuit. We spoke to every group of judges. If we could get 3 people together at a Rotary Club, we were there.
To tell them that
That
you were
we
operating.
take complaints from any quarter. That was well publicized. And again, that's when you saw the uptick in judges leaving, because Superior Court judges in their circuits felt comfortable complaining on another Superior Court judge in their circuit because they knew they didn't have to put it in writing. They could call Jeff.
Had we had a more formal or a more as anticipated procedural route to change the rules by the Supreme Court, do you think that the judge community would have felt more secure that their treatment or constitutional rights were being protected?
You know, the 1,300 or 1,400 judges we have, it's about the same number of police officers there were in Atlanta when I was a real policeman. And you're not going to get anybody to agree on much of anything other than what time do we eat, how much do we get paid, and we hate internal affairs.
I'm really confused about why the commission did not make changes as you articulate were needed, as many others articulated were needed. Why weren't those rule changes made, that procedural structure changed?
The procedural structure was changed. It was not codified in the rules that, hey, from now on we don't require anything in writing. But the rules already say that the commission on its own may institute an investigation. And quite frankly, during my tenure as investigator, I'm going to use a word you're not going to like, but the really good complaints that came in did not come in a formal complaint. They came in to Mr. Davis or myself or to a commission member on the phone or whispered in a courthouse or like that. Those were the complaints of substance.
So
most of the complaints that came in writing, I never saw and never had anything to do with.
So the oral complaints, the rumored oral complaints, serve the public's need in your position. Yes, that's your position.
It's an arrow in the quiver of getting to the root of public judicial corruption. Yes, but even with the complaint, take the judges that ordered me to their jury room to say we have a colleague that hadn't been at work in 2 months. That judge had a right to a public trial. Had that judge not left, I would have done a complete investigation. Maybe the commission would have filed charges. Maybe they wouldn't have. That's not my call.
I think Mr. Daylor left August 16th of 2016, and you as the investigator left, as you said, December 31st, 2015.
I left the same day I was reappointed to the commission.
Do you know if any case has been processed since January 1st, 2016?
I don't want to get all Katie Couric on you, but I don't know what you mean by processed.
Well, that's a good question.
Have they come in?
I know they've come in. Has the
I don't.
Has the commission taken any action on any matter since January 1st, 2016?
I am certain we have, if nothing else than dismissing complaints. I have asked on more than one occasion, and the chairman is familiar with this, that every complaint that comes in be sent to all the members. I'm through different ways. I know that's not happening. I don't know what my options are to fix that. I know what some of the lawyers I work with tell me I could do, but I'm trying to see how you guys fix this. And I'm trying also as the non-lawyer and as the perennial turd in the punch bowl to sit back and let these lawyers figure out how to fix this, and you guys. I can't be fighting every battle by myself, asking for every complaint that comes in. Like you guys, if I don't have 3 people that agree with me, I can't get anything done.
You use the word embarrassment for the current commission, but I'm really trying to get beyond that adjective and get to what's really happening. For instance, I can't figure out why an interim has not been chosen. That would involve first an advertisement or a public announcement we want applications. It might involve interviews. Are you aware whether the commission has done either of those things? Have you interviewed any candidates?
Not to be flip.
Have you issued any public statement that you're interested in people's resumes?
I talk to people all the time about the job,
Yeah,
and I've got a lot of candidates, and they're all saying, gee, that sounds like a great job. Let's see what the legislature's going to do. Let's see if the amendment passes. But quite frankly, and not to be flip, would you take the job right now, not knowing in January if it's going to exist?
It's going to exist, one way or the other.
I hope so.
It's not going to be disbanded.
Okay, but
I want to keep that clear.
But let's
It's
say,
not being disbanded. It's going to be reconstituted.
I understand that quite well.
Not only is it not going to be disbanded, it has work to do today that is not being done, in my opinion.
We got work to do 6 months ago that hadn't been done.
You agree with me on that?
Absolutely.
And
And as far as that's my fault, I'll take the hit for that since I'm here.
that's not where I'm going. Where I'm going is, tell me what the commission is doing when you meet. Does the commission meet? When was the last time the commission met in any way, by phone or by the 7? There are 6 members today, not 7.
Correct.
When is the last time the 6 members of the commission were notified in any manner that the 6 of you were going to meet in any manner to discuss any issue?
It would have been last week or the week before. The chairman may recall better than I. I was out of town working. I called in. It was a phone conference. They'd hired a lawyer to fight appearing and giving documents to you folks. So that would have been a meeting. And it was a 3-3 tie. And I know Title 16. I don't know Robert's Rules of Order. And I lost the motion, I'm told.
Are you aware whether Mr. William Hill has done any work since that meeting of 1 or 2 weeks ago?
No idea. I've not heard from him.
At the meeting...
Other than I got an email that, and William Hill, I worked with for many, many years. He's one of the finest.
He's a fine lawyer. He's a fine lawyer.
Worked at the Attorney General's office, made one of the best oral presentations before the U.S. Supreme Court I've ever heard. But he sent an email to me that after 11 years of college and journalism school, I have no idea what it said. So
his hourly rate is $550?
I believe so.
Has there been a retainer agreement signed with him?
I don't have any direct knowledge of that. I've just seen the emails back and forth that I've been copied on.
And his assignment to do work is not related to cases. It is only related to representation of to the 6 members of the JQC in relation to these proceedings. Am I right or wrong about that?
That is my understanding, yes, ma'am.
Back to the operations that are going on today, are there any other meetings since August 16th, 2016, that you've been present by phone or in present, where the hiring of an interim has been even discussed?
Not that I recall, but I would have to go and look at the minutes as they are to verify that, but I don't recall anybody talking about hiring a director. I
said interim. I said interim.
Okay, that too.
Has the commission made any distinction between interim and permanent?
Not in my presence. I was asked when I went back on the commission in, I guess it was the January meeting, would I be on the subcommittee to find a replacement for an investigator? And in hindsight, maybe I said the wrong thing, but I said there's, to the committee or to the commission, there's no one I dislike enough to suggest that they come work for you folks right now till we get it straightened out.
But you won't commit to voting for this amendment.
I didn't say one way or the other how I'm going to vote because I don't know.
Okay. Thank you, Mr. Chairman.
Thank you. Mr. Meadows, anything you have?
I just want to make two things clear.
Bring your mic around, please.
Two things clear.
I ain't no lawyer. That's an insult. And then you turn around and insult me and tell me I'm a turd in the punch bowl. Thank you for coming.
Mr. Powell, you have no questions? Mr. Coomer? It's number 2019, excuse me.
Yes, sir. Thank you, Mr. Chairman. Thank you, Mr. Hyde, for being here today. I appreciate your testimony and your willingness to participate. It's very important what we're doing, and as I said in the first meeting, there's probably not a more important function in our state government than to maintain an effective judiciary, and so I appreciate what you're doing. Just to be clear, you and I first met probably 6 months ago. Is that about right?
I've been hitting the head a lot, but I believe you.
Yeah, and that was after this process had already begun with the legislative process on the constitutional amendment, and it was only after that began that you and I met, correct?
It was after the debacle in Bartow Probate Court,
Yeah.
Yes, sir.
And I didn't really know you. The only thing I really knew about you is that you had been an investigator for the JQC. Since I met you, I have learned that you really have a very broad history and a long history of rooting out public corruption in the state of Georgia, and maybe beyond, but certainly within the state of Georgia. And I say thank you for your service. Thank you for your willingness to take on corruption that is public corruption that's hard to root out, and you face a lot of nasty characters, and you should be commended for what you've done over the years, and I appreciate it. I want to ask you kind of a...
Wasn't there a but there?
No.
Oh.
I want to ask you a sort of you might think there's a but when I ask you some of these other questions. But the first one is just kind of broadly, I mean, you're a member, you're a commissioner on the JQC.
That's what they tell me.
What is the purpose of the JQC, in your opinion, as a commissioner? Why do we have a JQC?
To protect the public, not to punish judges. We exist to protect the public from the very, very few judges that go outside the lines. I cannot stress enough the quality, and you're a practicing lawyer in a great circuit, as is Mr. Powell. I mean, most judges I've never met. I understand, Ms. Oliver, what the judges, I'm not so naive that I don't realize what they say behind my back. But like judges, when I go out, I get told by other judges, and so does Mr. Davis. It's true with Mr. Davis about how smart and thin and tall and pretty and funny I am. So I'm not naive enough to believe that. But the overwhelming number of judges do great work and are the best jurists in the country.
So, understanding that as the baseline for what the JQC is supposed to do, it leaves me with some concern about some of these other issues you've testified about today. One of the things you said is that you have trouble getting some of the members, some of the commissioners to attend meetings. What is the solution for that?
My solution would be that the appointing authority gets notified after you've missed X number of, and it's been suggested by some of you that we adopt uniform rules or that we act like the State Bar of Georgia. And with all due respect to the State Bar of Georgia, they, on the Board of Governors, I think they keep a list, and after you've missed so many meetings, you get, I guess they put something in your permanent file or something. I don't know. But I would suggest that if a member, unless medically incapacitated, misses a certain number of meetings, that the commission report, or the chair, unless it's the chair, then it'd be the vice chair, I guess, reports it to the appointing authority. The best way to have members appear, and the best way is transparency. There is no reason.
So open meetings?
There is no reason that our agency should not be subject to the Open Meetings and Open Records Act. I'm not talking about having a TV camera or a reporter in there when we're counseling a judge, but my mama has a right to know what kind of photocopier we're buying and why, or where's our office, or why are you paying this person X, Y, or Z. We are not a secret agency. This isn't a private club. We're a public agency that does some things confidentially. So I would protect the confidentiality, but the best way to ensure is public transparency, because the second meeting when 3 members don't show up and it's on Channel 2 News at 6:18 that night, they're going to be there the next week or the next meeting.
So what I take from that is if the solution is to report back to the appointing authority that appointed the member, is it your belief that the appointing authority is also the removal authority?
No. The removal authority vests only in the state legislature, the House of Representatives.
Through impeachment process?
Right.
Okay. You mentioned earlier that some of the appointing authorities haven't paid attention to who they've appointed. What did you mean by that, and who are you talking about?
I guess I could be talking about myself, too. I mean, the governor had 10 million different Georgians he could have picked instead of me, and they're eminently more qualified than I.
Let me think for a second. I don't want to go into specifics of individuals, Mr. Comer. We get into a contest then about, well, whether they had a right to be absent or something. I'd rather just leave it on a general basis, perhaps, as opposed to naming of individuals. Would you be all right?
That's fine. I'll move on.
We need good men and women that'll show up and vote and be fair. That's
the main thing.
Okay. A couple of times in the testimony today, you said that in a couple of different aspects that something was above your pay grade, and I think generally you were saying that you couldn't explain why a particular action was taken because it was above your pay grade. Can you tell us then to whom we should address questions to that would be somebody above your pay grade that could answer those questions?
Well, above my pay grade mainly meant when I was an investigator,
okay.
Staff investigator, where notwithstanding today, I really stayed in my lane as the investigator, and at the commission meetings, rarely speak. I looked at that as the time for the commission members to discuss the cases. I already know what's going on. And I only spoke when asked a direct question. The director, or at least with Mr. Davis and Judge Lane, the director would have the agenda and the chair would open the meeting, approve the minutes, all of that, and then go down the agenda of the docketed cases and then deal with whatever administrative work. But as a member, I can assure you I am outspoken. As the investigator, I was not.
Okay. You've sort of touched on answering this next question already, but I'm going to ask it and see if there's any additional information or different opinion. If there's a problem internally with the agency, I would expect the executive director to be able to fix that problem, whatever that internal problem would be. But if the problem with the JQC in particular, if there's a problem with the JQC and that problem is the conduct of a commissioner, then what's the appropriate avenue for correcting that behavior?
You mean should the commission not have a come to Jesus meeting with the aberrant member?
I'm just asking, what is the appropriate?
Well, I mean, we're here today.
Yeah.
And I think you've answered all my questions. Thank you very much.
Let me go back on one thing, just be sure and clear on this about the complaints, and I understand the fact that you may receive, or the commission may receive, information regarding conduct by a specific judge, and then I guess a decision's made not by you and not necessarily by the director, but by the commission as to what action to take. So I'm assuming if you or the director receive information about errant conduct of a judge, do you then go to the members of the commission and say, we receive information that leads us to believe there needs to be something looked into by the commission about this particular judge?
Generally speaking, the timing has depended on when the next meeting is. Let's say we have a meeting a week from today, and we get information. For instance, I got a call yesterday from a district attorney who says, I have a judge who's having a biblical relationship with a woman appearing before him right now. Something like that, we would not wait a week. I would report it to the director, and we would advise the chair or vice chair or both. If it's something like under 15.621 that unreasonably gives a judge a certain amount of days to rule, and we get inmate complaints saying, I've waited 3 months for a habeas ruling, things like that can wait to the next meeting, and we don't bother the commission members with that. But on an exigent circumstance, like, for example, with the gun in court, the commission has shown under proper leadership to be able to move pretty quickly.
So that makes it an emergency.
Yes, sir.
And by emergency, there are things that need to be handled and addressed immediately, as opposed to going through a process of having a complaint filed or conducting a hearing or whatever else is going on, right?
Yes, sir.
And I guess I look at some things that question is, what would you describe as being necessarily an emergency besides the gun situation? And as I mentioned earlier, I think I will understand, just like people who may be accused of a crime, once they're confronted with the facts, they're going to say, yes, I did do it, and plead guilty and move on from that side of it.
You're asking a guy to define an emergency, to me, is walking in on a holdup in progress at a liquor store on the corner.
Right.
So given that perspective, a JQC...
Happens your conduct. The conduct really happens in your presence.
Right. For example, we had a judge who was presiding over a molestation trial, and that judge, romantic interest, was texting during the trial to the defense attorney for the alleged molester during the trial. During the trial. Mm-hmm. The victim and their family are at a restaurant during the trial, and in their words, look in the corner of the restaurant and see the judge and the significant other playing footsie under the table. That, to me, would be something that you act on right then. Another example would be you have a trial going on and the judge is making bigoted, racist, crude comments about a lawyer appearing before that judge right then, and they're on Post-it notes, so much so that the staff of the judge says, you know what, this person isn't getting a fair trial because the judge is writing these bigoted, racist comments about the defense attorney. We had an obligation, as a matter of public policy and in the interest of justice, to move on that right then. Yeah, and you lawyers are going to say, well, that could have been fixed on an appeal. I don't know that.
Not necessarily. I'm just trying to get it, because I hear of things that may not rise to that level of being a, quote, emergency, but...
no, a judge sitting on the bench that does predominantly temporary protective orders for women that have been abused, mm-hmm. and the judge says in court with 200 witnesses, lady, do you even work or do you just spread your... That to me is something we acted on right then.
Mm-hmm. Mr. Kelly, did I ever miss you? I beg your pardon. I apologize. My mistake.
Your committee, Mr. Chairman.
My mistake.
Just a couple questions, Mr. Hyde. Thank you for being here with us. I just really want to maybe walk back to when you were an investigator and make sure we understand the process of what took place. If someone called you just from the public, and we can have a debate on whether complaints should be written and sworn. I believe it needs to be a more formal process than just a phone call, but there may be some middle ground. But if a complaint came to you as an investigator, who did you go to get approval from prior to going down to,
Either the director, the chair, the vice chair, and in the absence of the three, whatever member I could get on the phone.
And so really just anyone on the commission you would go to.
That's not what I said.
Well, I'm just trying to make sure you said any member you could get on the phone.
I said that as the fourth option.
Okay. I'm just trying to understand the process here.
I'm trying to help you
how
understand.
we're going. Today, how do y'all handle an emergency situation that comes up on the commission?
I don't know.
Okay.
If one of these cases happened today and I knew about it, I would send an email to the members and alert the chair.
I think this is maybe more of a statement than I'm done, Mr. Chairman. I just think it's important for the opponents of this measure continue to attack all of us here as trying to interfere with an independent state agency. But as of today, the JQC has no director, no interim director, and no investigator. They have no process in place to handle complaints that are being handled today. And that right there speaks of the magnitude of what we're trying to do here today and putting some accountability on an important state agency. Thank you.
I agree, and I've got to say one thing. With all due respect, I feel that if y'all are going down the road where you want every complaint sworn to and in writing,
No.
the judge that tried the chair and convicted the chair, we wouldn't have taken. The gun in the courtroom, we wouldn't have taken. The judge that asked his clerk, "What does your husband's semen taste like?" we wouldn't have taken that case. The judge that sexually assaulted two women in his office, he'd still be in office and perhaps sexually assaulting women. So if you're going to go down the road and require a sworn written complaint, expect it to get worse, not better.
And I think there should be a middle ground somewhere in the middle of that.
Of course. That's not what you said originally. I misunderstood you.
And to follow up with that, I think you're right. But I think there needs to be a means of, at least within the commission, ability to make a determination. Emergency has arisen, action needs to be taken through conduct of the commission.
Absolutely. And it always has been that way until recently.
And if it's not doing it recently, then that's another concern. And I keep hearing, until recently, you're talking about because of the way the commission's lack of functioning at this time.
There's 100 different reasons. It's just the perfect storm of dysfunction.
Do you know if they're handling anything as far as what might be considered emergencies at this juncture with the commission?
I have no direct knowledge of that.
Well,
But we have a meeting on the 30th.
But as far as a commission member, you have been told something needs to be done as a result of
No, sir.
conduct that may rise the level of emergency.
No, sir.
Okay. Ms. Oliver?
I just wanted to follow up a little bit because I've not made a decision that have to be sworn and written. I do have a strong belief that there's changes that need to be made in procedural steps. But the details of that, I'm really waiting for your work group, which I believe is probably doing good work to give me some guidance, me to make my own opinion, whereupon you may go ahead and make your own corrections as you should have done, in my view, a good
10
many
years
years
ago.
But it's totally erroneous for you to tell me or any of us that the JQC, when it had very good people on its staff and its officers would not have investigated a judge that pulled a gun out in public court because there was no formal written complaint. I just don't buy that. I think that's a little hyperbole to suggest that the potential danger of no written complaint would result in this incredibly bad behavior not being processed forward.
No, we have the rule of law, and if the rule is passed or the law is passed by you folks that says every complaint shall be sworn to and in writing, we've got to go by the rule of law.
Well, I just suggested there's a little bit of hyperbole in suggesting that the good people who were in place in many years would not have taken action with the egregiousness of the conduct you've described.
I understand that, but the good people also would obey the law, and I understood what the committee man said was that you were leaning towards a law that said we only accept cases in writing.
I don't accept that as being true.
Okay, well, I misunderstood.
It may be true eventually, but I certainly have not prejudged that at this point, and I don't want, again, the public to be informed that we at this table are about to mess up something that has operated appropriately in many cases.
I don't think you will.
Well, thank you, sir, for being with us today. I think we've had all the questions. I want to close out by noting and commenting the fact that only Mr. Hyde and now Mr. Tolley next week, as members of the commission, have accepted our invitation to come and appear. I think it's a statement of the lack of interest on part of maybe the other commission members who fail to appear. If you got to, and let the media send the word out, if you got a problem time-wise, we're still open to having those members come before us. It's not a inquisition. This is trying to get information to better understand what's happening with the commission so that we, the representatives of the public, have better insight about it. As Mr. Hyde noted, everything done by the commission is pretty much closed meetings and closed information. We don't have opportunity to even see what they're doing in normal administrative matters. So I'm still would like to be sure an invitation is open to the members, and one in particular, not a member of the commission, but to Ms. Moon, who's a state-paid employee. My concern is why she won't agree to appear. So we can find out more about her responsibilities and how things are handled administratively from the side of the commission.
Ms. Moon is a fine, loyal employee, and she was given a direct order, I'm told, not to appear. So Ms. Moon's following orders.
A direct order by who? Someone on the commission?
Yes.
Well, that's a shame. I mean, we're not we're here trying to get information, and to have somebody give that kind of direction is really a cause of concern on my part. And I think the other committee members, as to the fact that we're being denied the opportunity to get a full understanding of what's happening within the commission at this time, is a problem.
Well, I plan on being here at least in the back of the room every Thursday.
Understood. And as I said, next Thursday we will be convening at 1 o'clock rather than 10 o'clock, since Mr. Tolley, who's also a busy lawyer, will need to be here at that time. I want to have him give the opportunity to speak to us about his experience on the commission, as well as the work he and others are doing with the ad hoc committee that Justice Namis has been involved in. I think we are very interested in that approach.
Next to the hiring of Pastor Jeff Davis, the appointment of Ed Tolley is probably the best thing that's ever happened to the commission.
I can't argue with that. Thank you so much, Mr. Hyde. We'll stand adjourned.